Hello, everyone, and welcome back to the channel. Today, we are discussing one of the most fascinating and rapidly evolving areas of sports law and media business. So, basically, who owns the athlete, image rights, AI clones, and celebrity contracts in sports? Today, athletes are not just sports personalities, they are brands, influencers, digital assets, marketing tools, and now even AI generated virtual personalities. A cricketer's celebration, a footballer's hairstyle, a wrestler's signature line, and even a player's voice can generate enormous amount of commercial value. But the legal question is who owns these rights? Can brands use an athlete's face forever? Can AI recreate a player's image without permission? Can a sports franchise digitally clone an athlete after retirement? This is exactly what we will discuss today. Now, modern sports transform athletes into commercial properties. Athletes today can earn through sponsorship, endorsement, licensing deals, social media partnership, gaming collaboration, streaming content, NFTs, and merchandising. For example, you have Virat Kohli, Cristiano Ronaldo, Lionel Messi. They earn massive revenues not just through sports but through branding. In many cases, an athlete's commercial value exceeds their playing salary. This is why companies fight aggressively for endorsement contracts. An athlete today is essentially an intellectual property ecosystem. What are image rights? Image rights refer to the commercial use of a person's face, name, signature, voice, gestures, likeliness, reputation, and personality traits. These rights allow athletes to control how their identity is commercially exploited. For example, you have jersey advertisements, gaming avatars, action figures, sports video games, digital posters, AI recreation, and brand campaigns. All these involve image rights. In India, there is no separate statute exclusively governing image rights. Instead, protection comes from personality rights and privacy rights, copyright laws, uh, trademark law, and passing of principle. The landmark judgment ICC Development International versus RV Enterprises discussed the commercial exploitation of celebrity identity. Indian courts increasingly recognize that celebrities possess valuable publicity rights. Athlete endorsement contracts are highly detailed documents. Now, these agreements generally include exclusive clauses, morality clauses, social media obligations, licensing rights, image use permissions, territory restrictions, and duration clauses. For example, a sportswear company signing an athlete may prohibit them from endorsing rival brands. A franchise may also require mandatory appearance, digital promotions, and commercial shoots. Today, social media has become major contractual obligation. Athletes are often contractually required to post promotional content, attend influencer campaigns, and engage with brand audience. Morality clauses are especially important if an athlete becomes involved in criminal allegations, doping controversies, or offensive statements. Brands may terminate endorsement deals. We have seen this globally across sports industries. Let's talk about the most futuristic and controversial topic, AI generated athlete clones. Artificial intelligence can now recreate voices, generate realistic videos, mimic facial expression, and create digital replica of athletes. Let's talk about AI plus athlete, their identity is equal to digital publicity rights conflict. Now, this is a major legal concern. Imagine Imagine an AI generated cricketer promoting betting apps, a retired athlete appearing in advertisements without consent, or deepfake videos damaging a player's reputation. Who owns these digital replicas? Can AI companies train models using athletes' footage without permission? These are major unresolved legal questions globally. In the United States, publicity right laws are more developed. In India, courts are slowly recognizing digital personality protection. Recently, celebrities and public figures have increasingly taken action against unauthorized AI generated content and deepfakes. Sports videos, NFTs, and digital ownership. Sports gaming itself is another major industry. Games such as EA Sports FC, Cricket 24 license athlete identities for commercial use. Game developers negotiate player likeness rights, motion capture rights, and branding permission. Now, NFTs and metaverse projects are adding another layer. Athletes can monetize digital collectibles, virtual jerseys, signed moments, and blockchain based assets. But ownership disputes can arise between athletes, clubs, leagues, and sponsors. Let's talk about legal challenges in India. India still lacks a comprehensive legislation specifically governing personality rights, AI generated replicas, athlete publicity rights, or digital exploitation. Legal protection currently comes from Article 21 of the Constitution, trademark law, copyright law, passing of action, and privacy jurisprudence. The rise of AI generative makes regulation increasingly urgent. India may eventually require AI disclosure laws, digital consent frameworks, and athlete data protection regulation. Sports law in India is rapidly evolving alongside technology. The modern athlete is no longer just a sports person. They are intellectual property, entertainment brands, digital influencer, and now even virtual identities. As AI continues to evolve, the battle over ownership of identity will become one of the most important legal issues in sports and entertainment law. Quick question is no longer who owns the game. The real question is who owns the athlete's identity. The future of sports law will depend upon how legal system balances innovation, commercial interest, privacy, and human identity. Thank you so much for watching this session. If you enjoyed this video, do like, shares, and subscribe to the channel. Also, comment below, should AI companies require mandatory consent before digitally recreating athletes? See you in the next session.